All right, we appreciate you being here to argue this case. Are you ready to proceed? Do you want some rebuttal, part of your 20 minutes for rebuttal?
Thank you, Your Honor. Yes, my name is Margaret Bailey Turner. I'm here with the Appellate Division of the Public Defender's Office. And yes, I would like to reserve 5 minutes for rebuttal, please.
5 minutes?
Yes, sir.
Certainly.
Am I
All right.
speaking at an okay volume for you all? I know you had.
Pardon?
Am I speaking?
He just told
I'll
you.
speak up just a little bit.
Please, it's not that bad, but my hearing, but speaking up is very helpful.
Yes,
So
sir.
thank you. I want to hear what you have to say.
Sure.
All right.
The only issue before this court today is whether the trial court abused its discretion when it ordered Mr. Jordan to serve his entire sentence in confinement after he pled guilty to 2 charges stemming from an incident in Dyer County in December of 2022. We ask today that this court find that the trial court abused its discretion and remand for proper sentencing or order that Mr. Jordan serve the rest of his sentence either on probation or in community corrections. As I mentioned, the charges here stem from an incident in Dyer County. Mr. Jordan pled guilty to 2 charges, one unlawful possession of a firearm and possession of less than 1/2 ounce of marijuana. As part of his plea agreement, Mr. Jordan agreed to 8 years for count 1 and 2 years for count 2 for a total effective sentence of 10 years. Abuse of discretion, as this court knows, and as relevant here, happens when a trial court fails to properly consider the purposes and principles of sentencing, and when it bases its decision on a clearly erroneous assessment of the proof. In this case, the trial court did abuse its discretion when it failed to properly consider the purposes and principles and based its decision on an erroneous assessment. I'll turn first to the purposes and principles of sentencing. When a trial court fails to articulate how its decision furthers the purposes and principles of sentencing, it abuses its discretion. And proper consideration of the purposes and principles requires that a trial court place sufficient findings on the record for this court to be able to conduct a meaningful appellate review. Our position in this case is that the trial court here over-relied on Mr. Jordan's criminal history. While we of course concede that Mr. Jordan's criminal history is a necessary and valid consideration, it seemed to rely on Mr. Jordan's criminal history sort of in lieu of considering other sentencing factors which it was required to consider.
Such as?
Yes, sir. Specifically, we do point to the statistical information that the trial court was supposed to consider, but really sort of just when thinking of the purposes and principles of sentencing, the idea is for the trial court to sort of take a holistic view and of course, as this court has said, there's no need for the trial court to say any sort of magic words, but it should have placed sufficient findings on the record for this court to be able to conduct appellate review of the sort of whole holistic case and to ensure that the sentence is proper for the defendant and for society.
In fairness to the court, though, and I'm asking you to comment on your friend's brief, but his criminal history took up 1.5 pages of their brief, I believe.
Yes, Your Honor. It did.
There was a lot to go
We
through.
certainly do concede that Mr. Jordan has an extensive criminal history, but we argue that his criminal history really indicates more of a need for rehabilitative measures over confinement.
Okay, let me ask you this. You was talking about rehabilitation measures. It seems like he's been on probation a bunch.
He has had probation, yes, sir. But there is no evidence in the record that Mr. Jordan has violated probation before.
But isn't the purpose of probation to try to, I mean, obviously, at least when I used to consider probation, was the idea that you're going to be given this opportunity to change your behavior, to either learn some useful education or trade so you don't go back into criminal, I guess, activity again. In this case, he just went right back into his criminal activity. There was no real break in his behavior based on all these times he's been on probation.
I would like to point out that his more recent criminal history, Your Honor, has admittedly, as we can see, he does have an extensive criminal history, but his most recent history has declined. He has been declining, and the state sort of paints this image of Mr. Jordan as a lifelong criminal, but I really do think that glosses over Mr. Jordan's declining recent criminal history and the fact that a large portion of his criminal history is drug-related.
Well, and also guns, and the fact that he keeps getting charged with being a felon in possession is something that I think court did take into consideration.
Yeah.
Because it shows he's not following the rules, and from the standpoint he knows he's not supposed to possess a firearm, yet he continues to possess a firearm.
Yes, Your Honor. We would just again say that the Mr. Jordan's criminal history here, while he did possess a firearm in this scenario, that he was deemed a suitable candidate for community corrections, and that there were alternative sentences available for the court in this situation to afford Mr. Jordan an alternative sentence.
Well, really, if a trial court's going to put somebody on supervision, they have to make the determination that they're going to comply with the terms, right? I mean, that's basic. Okay. So the defendant's criminal history showed several failures to appear to court, did it not?
I just note one, Your Honor, on mine.
Well, I'm going from the state's brief, but they had one as recently as 2022, I believe. Is that correct, when we look at the record?
My technical record shows failure to appear, I'm so sorry, in 2007, and that's the only failure to appear that I
There's
have
one
in
in
my
2022.
record.
There's one in 2022, and there's one in 2007, which resulted in apparently a conviction and a probationary sentence.
We're just taking that from the state, I'm taking it from the state's brief.
Yes,
So
Your
if they're
Honor.
wrong, they're wrong.
The prior record that I have available in front of me shows 2021, I'm sorry, of misdemeanor. I don't have any from
Right.
2022,
But
so
when-
sorry, I don't.
But when somebody is supposed to appear for court, they're not, and they fail to do so, they're not abiding by conditions of the court. You'd agree with that, wouldn't you?
I would agree with that, Your Honor, yes.
Okay, so that, in a way, is similar to the ability to comply with terms of probation, authority giving a person rules to follow and.
Sure. Mr. Jordan agreed, though, in this case, that he would be willing and able to provide by the probationary rules that were set out before him. I understand the court's hesitation, but from the record that we have before us, Mr. Jordan did agree and and could have agreed and could have abided by the terms of probation or community corrections.
Well, I hope
if
his
he-
intentions are good, that he will follow them, but when we look at the record, do you know if any of his crimes in the criminal history as laid out, did any of his crimes, were they committed while he was on probation or other court supervision, besides the failures to appear?
My technical record shows no probation violations aside from his failure to appear. The trial court here and the state also, the state argues that the trial court fulfilled its obligation. I'll just go a little bit deeper into the statutory considerations. When it considered the factors of confinement, but we argue that in this case, the factors of confinement are only a portion of the statutory factors which a trial court is supposed to consider when imposing a sentence. and specifically point to the statistical information that trial courts are required to consider. This trial court here engaged in sort of a recitation of the factors which it is required.
What was the actual consideration the court articulated what it was considering? What did the court articulate?
The court listed a list of factors which it was supposed to consider. I don't have,
Well, the thing, at least my understanding of the record is, he talked about the fact that the defendant has a long criminal history involved, there's a number of offenses involved the use of a firearm, and he had been previously prohibited from possessing those kinds of firearms, that the fact that he had been on probation so many times before and continued to reoffend indicated that there was a low probability that he would be able to complete probation. Weren't those some of the findings the court made?
the court did make those findings, yes, sir, but those, yes, Your Honor, but those are not the only findings which the court is required to make, and there aren't enough findings otherwise outside of Mr. Jordan's criminal history for this court to be able to really conduct a meaningful appellate review of all of the factors of confinement that the court ruled upon in this situation. I'll move, if the court has no further questions, I'll move to the trial court's erroneous assessment of the proof, just really briefly. When the trial court did consider factors outside of Mr. Jordan's criminal history, it did so based on an erroneous assessment of the proof. It considered Mr. Jordan's employment history and agreed with the state's characterization that the trial court, I'm so sorry, that Mr. Jordan began working only 3 weeks before his sentencing hearing, when in fact Mr. Jordan had been employed for 3 consecutive years leading up to his sentencing hearing and had was by all accounts, according to the testimony, a model employee. Additionally, the court found that Mr. Jordan, and I think that these would go to Mr. Jordan's ability to abide by the rules of probation, found that Mr. Jordan had no transportation of his own, which is true according to the record, but he does have a supportive family and a supportive community, has been able to stay sober, in fact, for periods of over 6 months in the community based on family support. And according to his employment history, always shows up on time or early to his job, so has a demonstrated ability when in the community to abide by sort of the standards of collegiality of, you know, showing up and being where he's supposed to be. I would also add that the trial court here found that Mr. Jordan had no permanent address, which would also interfere with his ability to abide by the requirements of probation. But the record shows that he does, in fact, have a permanent address. It reflects his aunt's address as his permanent address. He testified to the same at trial and said that if he were allowed to serve his sentence on probation or in community corrections, that he would be living with his aunt. So if the court has no further questions, we would ask that the court remand Mr. Jordan's matter for proper sentencing or order that he serve the rest of his sentence on probation or in community
Is he on
corrections.
bond now pending appeal, or is he serving his sentence
No,
somewhere?
sir, he's incarcerated.
Okay.
Thank you.
Thank you, Counselor. General, good afternoon.
Good afternoon, Your Honors. May it please the court, Katie Neff on behalf of the state. Your Honors, this court should affirm the judgments of the trial court because the trial court's order for confinement was justified, given that the defendant's criminal history evinces a lifetime of criminality and violence, given the seriousness of the offenses, and given that the defendant has been given myriad opportunities to rehabilitate through his 14 or 15 prior grants of an alternative sentence. And so we would respectfully ask this court to affirm. I want to start by making clear what the terms of the defendant's plea agreement included. The defendant agreed to the length of the sentence, but he did not agree to the manner of the service. And as my friend pointed out, I did have a misplaced modifier in my brief, so I do apologize for the sloppy writing there. But in considering whether to impose a sentence of confinement, the trial court here did make a careful consideration of the sentencing factors and made factual findings to support its decisions. And so it's certainly the record before this court is sufficient for this court to make meaningful review. Therefore, the standard is abuse of discretion with a presumption of reasonableness. And in order to overcome that presumption, the defendant has to show that the trial court's order wholly departed from the principles and purposes of sentencing, and they cannot show that here. So I'm going to start by going back over some of the facts of how the defendant ended up in court in the first place, because the trial court, I believe, did not believe it was allowed to consider that, but I believe this court, it's fair for this court to consider it. The defendant was in an argument with his ex-girlfriend, and the argument escalated to the point where he brandished a shotgun, and then escalated more to where he struck her in the head with the shotgun. I mean, a shotgun's a very large weapon, could cause damage, you can imagine. And then he pointed that shotgun at her 3 minor children and threatened to shoot all of them. So this is very serious conduct. Police were called out responding to an aggravated assault. And when they got there, they had to break down the door to get to the defendant. They found the shotgun near him. They also found a backpack with 3 other firearms and 176 grams of marijuana. So this court is allowed to look beyond the plea deal to look at what actually happened that brought the defendant to court that day. And so looking to the factors of confinement, I'll start with seriousness of the offense because that sort of ties into what the proof is. These were very serious offenses. First, possession of a firearm by a felon is a serious offense in and of itself. We know that a firearm can cause much damage when in the hands of a bad actor, and felons have already demonstrated their unwillingness to comply with our most basic moral laws. But more than that, the defendant had previously been convicted of being in possession of prohibited weapons. So this is something he's done before, he's doing it again. And as the trial court pointed out, the trial court was seeing more and more of these kinds of cases. And so sort of touching on that need to provide deterrence to others and also to the defendant, that these cases are happening more and more. So a sentence other than confinement would depreciate the seriousness of these offenses. But more than that, looking to the defendant's criminal history, the defendant's criminal history, as Judge Campbell was pointing out, is very lengthy. He had 24 misdemeanor convictions, 5 felony convictions, 2 of which were violent felonies. And again, some of those were drug sales, some of those were prohibited weapons possession. And this is a defendant who has demonstrated he's not going to comply with the law. And so it is based on that criminal history that a sentence other than confinement. Confinement is necessary to restrain a defendant to protect society. But then finally, the trial court found that the defendant had been previously and frequently given the opportunity to rehabilitate himself through those 14 or 15 prior grants of an alternative sentence. Defendant did receive we know that he received drug classes at some point, but he never indicated he was even a drug addict, just that he had been using marijuana for most of his life, including just several weeks before the sentencing hearing. So I think the proof in the record certainly supports the trial court's imposition of a sentence of confinement. And I want to make just a few final points to address some things that my friend brought up. She says that the trial court did not consider statistical information of similar crimes, but that's not true. This trial court specifically mentioned the frequency with which he's seeing these kinds of crimes, and that played a factor in the trial court's ultimate sentence. My friend says that the defendant's most recent criminal history has been declining, but the facts of this case would say otherwise. This was a horrific chain of events, and these are serious crimes. It has not been declining. And finally, she faults the court for making an erroneous assessment of the proof. Well, let's talk about each of those 3 points. She says the trial court improperly or erroneously determined that the defendant had only worked 3 weeks. That's actually not what the trial court was saying there. If you look at that portion of the record, the trial court is saying that the trial court was assessing whether the defendant could be successful. And you're looking at, do they have employment? How likely are they to stay employed? The court noted that at the current job that the defendant was employed at, he had only been there for 3 weeks. And the trial court did later, in another part of the sentencing hearing, credit the defendant for having a strong work ethic. But the fact that the defendant had only been at his current employer for 3 weeks was certainly justifiable, or justifies the trial court's determination that probation was not a good fit, or an alternative sentence was not a good fit. She herself stated that it is true that the defendant did not have regular transportation, and so the trial court's determination about the defendant's transportation was not a clearly erroneous assessment. Finally, she says that the court made an erroneous assessment as to the defendant's permanent address. The record does not show that the defendant had a permanent address. There's a mention in the pre-sentence report, which was completed in March of 2024. There's a mention that his permanent address is with his aunt. But then at the sentencing hearing in July, just months later, clearly his situation had changed. When asked where he lived, he said, sometimes with my father, sometimes in a motel, and yeah, my aunt will let me stay here if I get probation. The court's determination that the defendant did not have a permanent address was not clearly erroneous. And I want to just put all of this in context. That was a small part of the trial court's decision. The trial court's decision was primarily on those 3 factors of confinement. There was most discussion about the defendant's criminal history, his failed attempts at an alternative sentence, and the seriousness of the offenses. And so, for those reasons, the trial court's order was proper, and he did not abuse his discretion. Unless the trial court has any other questions, I'd ask that you affirm.
All right, thank you, General.
Thank you, Your Honors.
Your Honors, the state points out that the facts of this case are admittedly not excellent for Mr. Jordan, but we do ask that the state here look past the facts at the record, which shows that, again, Mr. Jordan took responsibility for his extensive criminal history at trial. His record shows, again, a clear de-escalation of criminal activity. He has been largely compliant on probation in the past. And the pre-sentence report here points out that Mr. Jordan, it highlights that Mr. Jordan would be a good candidate for alternative sentencing. He was deemed a suitable candidate for community corrections.
Well, and that's I guess there's 2 ways of looking at it. You can be eligible for community corrections, but not be a good candidate for community corrections, as well as you can be for probation. You can be eligible, or you can be eligible to be considered for probation, but that doesn't mean that you should get probation. The burden is on the defendant to prove his suitability.
Yes, sir. And again, we would argue that the record here supports a strong community support, strong family support, an excellent employment.
Well, let's break this down from the standpoint of the judge having to make that decision. He has strong family support, but he's been, even with his family situation, he's been committing crimes for 20 years. So, the judge has to balance all that. the totality of the circumstances, and it's not just one factor, another factor. In this particular case, you would have to admit that his criminal history is a huge problem for him in considering alternative sentencing. And the fact that he's been on probation 14 times before and has continued to commit criminal offenses kind of skews against him being considered a good candidate for further probation attempts, don't you think?
Again, there are many factors which in Mr. Jordan's criminal history, which the court considered sort of extensively in this case, that show that Mr. Jordan requires some sort of rehabilitation. And it's our position that in this case, that Mr. Jordan would have benefited from, when considering the totality of the circumstances, as you mentioned, Your Honor, that Mr. Jordan, that so many other factors weighed in favor of Mr. Jordan being afforded alternative sentencing here, that the trial court erred when it ordered Mr. Jordan to serve his entire sentence in confinement. And if you have no other questions, we would ask that this court remand for a proper sentencing or order that Mr. Jordan serve the rest of his sentence either on probation or in community corrections. Thank you.
All right, thank you. You've done an excellent job arguing your case, and your brief was excellent, as was the state's. And both of those briefs and arguments are very beneficial to us in making a decision. Mr. Jordan is very fortunate to have you and your office here on his behalf. So thank you. Hope to see you again.
Thank you very much, Your Honor. Thank you.
Certainly. All right, does that conclude the docket for today? All right, we're in recess until whenever. Yeah, forgot what month it was, till April. Yeah, that's when we'll be.